Welcome, welcome. Did anybody say anything?
No, we're recording.
Oh, okay, thank you. Well, welcome to this domestic relations section of the Fayette County Bar Association. Our program this month is Grandparent Visitation in Kentucky, Challenges and Changes. Today's speakers are our friends, Anna Dominick and Ann D'Ambrosio. Most of you probably know them, but I will introduce them briefly. Anna Dominick graduated from the University of Kentucky College of Law in 2008. She spent her first few months out of law school as Judge Masterton's staff attorney. She has practiced family law since 2009, primarily focused on high asset divorce cases and high conflict custody cases. She has chaired the Fayette Bar Association's Family Law Section twice and now serves on the Kentucky Bar Association's Family Bar Section. She has been certified as a parent coordinator since 2019 and enjoys serving as a parent coordinator very much. Anna has served on the Grandparent as Parents Community Planning Committee for many years. Ann D'Ambrosio was born and raised in Montana. She graduated from Transylvania University with honors and worked as a field archaeologist for 3 years before entering law school. Ann graduated from the University of Kentucky College of Law in 2007. She has been in private practice since 2008 and opened her solo practice, the Family Law of Kentucky, in 2019. Ann has been recognized for her extensive pro bono efforts and also volunteers with the Grandparents as Parents Annual Conference Planning Committee, Lexington Humane Society, and Fayette County Citizens Foster Care Review Board. Ann serves on the board of directors of the Mediation Center and acted as the KBA Family Law Section's treasurer from 2015 to 2017, and as the FCBA Domestic Relations co-chair from 2014 to 2015, and again presently, and we co-chaired the section together this year. Thank you, everyone, and ladies, whenever you're ready.
And oh, there you are. I lost you for a second on my screen. And it's very weird. So we were asked to present about grandparent visitation cases today. I am currently representing a grandparent in one of these and a parent in a separate one. So I've been kind of fascinated by this case law and how you actually practice these cases. So what Ann and I wanted to do is go over the current status of the law, because the law has changed in Kentucky in 2020. And on Friday, a new case was issued that sort of changes some of this. So we're going to talk about that case too. But we thought it was helpful to kind of go back to square one with these cases and talk about Troxel versus Granville, which I'm going to go through very quickly because I assume most of you know about that case. I remember talking about it in my con law classes in law school. So Brad Troxel and Tommy Granville had 2 children together. Jennifer and Gary Troxel were Brad's parents, so they were the paternal grandparents of these 2 girls, and they regularly visited their grandparents even after Brad passed away. And then at some point along the way, Mom informed the Troxels that she no longer wanted them to see her children as much as they had been seeing them. And so the Troxels, the grandparents, filed for grandparent visitation in Washington state. Now, Washington had a very broad statute. It essentially said anybody could petition the court for visitation. There were very few limits on it. And so when they did that, they were granted rights. And the case went all the way to the US Supreme Court. When the US Supreme Court got a hold of this case, they had big problems with how broad the Washington statute was. And how kind of limitless it was for anybody and everybody to file an action asking for visitation of children. And they determined that parents have a fundamental right to make their decisions. That's basic con law. We know this. I don't know if you remember the concept of Prince Patriae from constitutional law, but parents have a fundamental right to make the best decision for children, and it is hard for the state to impose and infringe upon those rights. And so in Troxel versus Granville, the Supreme Court found that as long as a parent is fit, a trial court should interject their own beliefs and opinions into that parents' decisions, and that we start from this presumption that a fit parent acts in a child's best interest, and that any of these grandparent visitation statutes must provide protections for a parent's fundamental constitutional rights to parent their child as they see fit. So the focus of Troxel versus Granville essentially said that parental decisions are given special weight, and any statutes that trample on that special weight and those special protections under the US Constitution must be narrowly tailored. And at the end of it, I just put in this outline some of the good quotes from Troxel. The things that I've been thinking a lot about in my case, particularly where I represent the parent, is this quote: "The burden of litigating a domestic relations proceeding can itself be so disruptive of the parent-child relationship that the constitutional right of a custodial parent to make certain basic determinations for the child's welfare becomes implicated." Because one of the things that I've thought a lot about, especially in a grandparent case, is how damaging litigation is to the entire dynamic and the entire relationship between these two opposing sides. In my case where I represent the parent, I don't know that she's ever going to feel good now about handing her child over to these people after they have put in pleadings that she's not trustworthy, that she's a liar, that she's self-interested. And if they end up with any time, how is that relationship actually going to work? And I think that's what the court was getting at with a lot of these issues is you have a fundamental right to parent your child as you see fit, and then litigation will ultimately damage that relationship. And how do you essentially co-parent with someone who has created a lot of damage through litigation? So I think we as practitioners have to be mindful about how we practice these cases, especially if we represent grandparents. Because I think in my cases where I've gotten grandparents some time sharing going forward, it's because they've been apologetic. They've been willing to change and listen to parent concerns. And frankly, they've been willing to keep it out of court. They've been willing to mediate and listen to the parents and learn from their mistakes and change their behaviors. And that's how they've gotten their time back. And I kind of think that's what the end was getting at in Troxel versus Granville, was the court recognizing that a lot of this is really disruptive to people's lives and damaging in ways that are really hard to fix if you keep litigation high like this. Taking it all the way to the US Supreme Court, I feel really bad for the mom in Troxel versus Granville because I can't imagine how much money she spent on this litigation. And that's what the Supreme Court ends their discussion with. So now I'm going to turn it over to Anne to talk about Walker versus Blair.
Okay, thank you. And thank you, Anna, for doing this. I know that you are slammed busy right now and we appreciate it. Okay, so in the context of Troxel v. Granville, we had a series of cases come out through Kentucky interpreting our grandparent visitation statute. And that statute is, of course, KRS 405.021. We've got a copy of it up on the website for you all to download if you haven't already. But essentially, the Kentucky courts were kind of muddling through and trying to apply the standards of Troxel as best they could. And there was a case that came out in 2004 that I want to talk about briefly in the context of Walker v. Blair. And that case is Vibert v. Vibert. It's 144 Southwest 3rd 292. It's a Court of Appeals case. And essentially, it gave the courts some good guidance and some factors to examine in making the determinations under Troxel. And Vibert tried to codify Troxel as best it could. They made it very clear, the Court of Appeals did, that you don't have to prove that disallowing visits harmed the child. They said that that was an unfair burden of proof. But then they set out their 7 factors to consider. And those 7 factors are set out in Walker v. Blair and adopted in Walker v. Blair. And I'm going to get into those in a minute. But the important part about Vibert is that it said that grandparents must prove by clear and convincing evidence, not the preponderance standard set out in King and its progeny and actually mentioned in our statute, that visitation is in the best interest of the child. So it adopted the findings of Troxel, made it a little bit less strenuous on grandparents to get the visitation. You don't have to prove that keeping me away from the child is going to harm the child, makes it a lot easier, and gave them a lot of guidance in the form of these 7 factors. So adopting those 7 factors, the Walker v. Blair Supreme Court case came out in, I believe, 2012. Walker v. Blair, like many of these cases, has a really sad fact pattern. The dad died by suicide. He and the mom were apparently no longer together. She had her own husband, the stepdad of this child, who was 5 years old at the time of the death. Mrs. Blair was the dad's mother, the paternal grandmother, and after her son died by suicide, apparently she called the mom and asked her if she was happy that her son had committed suicide. And there's also some suggestion in the verbiage in this opinion that the grandmother blamed the mom and stepdad for contributing to the son's suicide. So after that, mom says, "All right, you're toxic. I'm cutting you out of this kid's life." And grandma files her visitation petition. So Walker v. Blair, as I said before, it's important for a number of reasons. But what I like as a practitioner is that it gives you a roadmap. It gives you this very clear way that you have to go about proving your grandparent visitation case. What I don't like about it is that it's a really hard standard of proof if you're the one representing the grandparent. So it makes it very clear what you have to do, but what you have to do is pretty strenuous if you're going for grandparent visitation. So Walker v. Blair goes over Troxel and says, essentially, a fit parent's wishes are not just a factor to consider in determining what is in the child's best interest. Rather, the constitutional presumption is that a fit parent acts in the child's best interest, and that's the starting point for the trial court's analysis. So one of the things that Walker does is it makes it very clear that the parent's fitness is not on trial here. That's not supposed to be the court's inquiry. Really what's supposed to happen here is that we start from the presumption that the parent is fit and that they're acting in the child's best interest, and then we take it from there. It also codified that central tenet of Troxel, which is that the due process clause requires that a fit parent's decision be given special weight because of the presumption that a fit parent acts in the child's best interests. And it says about 12 times throughout the opinion, so you can take it to the bank, that the due process clause does not permit a state to infringe on the fundamental rights of parents to make child-rearing decisions simply because a state judge believes a better decision could be made. So long as the parent is fit, there will normally be no reason for the state to inject itself into the private realm of the family to further question the ability of that parent to make the best decisions concerning the rearing of that parent's children. So I think we talked a little bit about Vibert adopting the clear and convincing standard. Walker doubles down on that and says that a grandparent petitioning for visitation must rebut the presumption that a fit parent acts in the child's best interest with clear and convincing evidence that visitation with the grandparent is in the child's best interests. In other words, the grandparent must show that the fit parent is clearly mistaken in the belief that grandparent visitation is not in the child's best interest. So essentially, you don't have to prove that the parent is unfit in the context that they shouldn't have custody of their kid. You have to prove that they're making an unfit choice in denying grandparent visitation. And you have to prove it by clear and convincing evidence. As we all know, that is a tough hurdle to clear. And the other thing that I really like about this case is that it gives you examples of how to do that. And it says that except in special circumstances, clear and convincing evidence of a loving relationship between a child and grandparent is not enough to overcome the presumption that a fit parent acts in the best interest of the child. And Kentucky courts cannot presume that grandparents and grandchildren will always benefit from contact with each other. If the only proof that a grandparent can present is that they spent time with the child and attended holidays and special occasions, this alone cannot overcome the presumption that the parent is acting in the child's best interest and the grandparent visitation is in the best interest of the child. The grandparent must show something more, that the grandparent and child shared such a close bond that to sever contact would cause distress to the child, which is the fact-intensive inquiry. So photos of you at the school play and on at Thanksgiving dinner with your grandchild are not going to cut it. And very kindly, they did give us 2 examples of ways to show that special and unique bond between grandparent and grandchild. And those 2 examples that they give are if the grandparent has provided like extensive babysitting services, or if the grandchild lived with the grandparents, either with or without the parents at some point. Both of those are great examples. Anna and I were kind of talking beforehand and trying to rack our brains about what other kind of examples could you use to prove that special relationship? And we would love to hear any kind of suggestions or success or failure stories that you all have as practitioners, because I'm always looking to expand my repertoire of ways to shoehorn grandparents in. So the Walker v. Blair court goes on to talk about the fact that the mother did not have the burden to prove that the grandmother's visitation was not in the child's best interest. The grandmother had the burden of proof, and they overruled Baker v. Perkins in that context. They also noted that prior holdings where courts had talked about the fact that this will be a beneficial relationship to the grandchild and the grandparent, they say, no, we don't care about what's best for the grandparent. The only consideration is the best interest of the child. So yeah, it may be nice for the grandparent, but that's not something that basically we can't use that to tug at our heartstrings and sway our decisions. They talked about the Vibert factors, and I'll just go over those briefly and also offer some of their comments on them. The first factor is the nature and stability of the relationship between the child and the grandparent seeking visitation. Obviously, you need to be able to show that you've got that very special bond with your grandchild, so this is a huge factor. But the stability part, the Vibert court, echoed by the Walker v. Blair court, talks about the fact that when you're making the fitness inquiry, you are talking a little bit about parental fitness in terms of the child's stability and the mental health of everyone involved. So that's kind of where you get that consideration that starts to tread into, I think, other portions of our family law statutes where we're talking about fitness standards. The second factor is the amount of time the grandparent and child spend together. That's a pretty straightforward one. Although, of course, it's always going to be an inquiry as to how much time they were allowed to spend before the schism versus after, if it was totally cut off, and how long they've been cut off, and all those sorts of considerations. The third factor is the potential detriments and benefits to the child from granting visitation. That is very broad. And number 4 hits directly on what Anna was discussing in Troxel, the effect granting visitation would have on the child's relationship with the parents. Because essentially the child-parent relationship cannot be allowed to be deteriorated because of the introduction or reintroduction of the grandparent-grandchild relationship. The fifth factor, the physical and emotional health of all the adults involved, grandparents and parents alike. This gets on the fitness issue with respect to the parental decisions. The Walker v. Blair court talks about this notion that you can get a sense of whether the parent is making fit decisions in general via how they're living their life. Have they moved around a bunch? Are they unstable? Are they not able to really make fit decisions because in the grandparent realm, because they're not making fit decisions in other realms as well. But again, we're not to put the parents on trial. So it's one of those kind of catch-22s, I think. The sixth factor, the stability of the child's living and school arrangements, that again plays directly into number 5 and the stability factors that we're looking at in terms of fitness. The seventh factor is the wishes and preferences of the child. This can be where I think a GAL or an FOC can be helpful in these cases. And to that list, the Walker v. Blair court added an 8th factor. And again, this list is not dispositive and not all encompassing. These are just factors to be considered, but certainly a court can consider other things. But the 8th factor is the motivation of the adults participating in the grandparent visitation proceedings. They talk extensively in Walker v. Blair about whether or not vindictiveness or spite alone is enough to turn away a grandparent from visitation, because typically a parent's decision just is allowed to stand. But that's one of the things that the court will look at. Are you motivated by spite, either as a parent denying visitation or as a grandparent seeking visitation? One of the other really important things that Walker v. Blair did, which I think will become more important as we go through some of the subsequent case law, they said that just because your child is dead does not mean you have to go in seeking grandparent visitation under subsection 3 of the statute. And subsection 3, of course, is the section that says that you can get non-custodial parental visitation if you're paying financial support for the child, and the parent denying you visitation is not your child. It's your child is the deceased child. So that means that grandparents can still go in under subsection 1 even if they have not, even if their child is deceased, which is important because a lot of grandparents either one, don't have the time or inclination to do non-custodial parental visitation. As a fundamental matter, what does non-custodial parental visitation mean now that we've got this changing kind of landscape about what typical parental visitation looks like, and we now have the presumption of equal time. And of course, some people can't afford to pay child support in the absence of their deceased child, and that wouldn't be an option to them if they could only go in under 3. So it's important that grandparents whose own child, a grandparent whose own child is deceased, can be permitted to go in under subsection 1 of the statute. And then the other thing that I wanted to mention in the context of Walker, it's really kind of a side note. There's this case law, KCO versus the Cabinet. It's 518 Southwest 3rd 778. And I will post that citation in the chat as well. It's a Court of Appeals case from 2017 that makes it clear that only the 4 biological grandparents have standing to seek grandparent visitation under our statute. So Walker v. Blair, I think that it's important for a number of reasons. It hammers home so much of the verbiage in Troxel, and really, as I said before, gives us this clear roadmap. And it kind of gives us the guidance that we've been needing, and it is largely still good law. So with that context in mind, I will turn it over to Ms. Dominick so that she can tell us where we went from there.
So Troxel was decided in the year 2000, and since 2000, states have been grappling with grandparent visitation statutes and how to narrowly tailor them, but still keep grandparent visitation alive as a viable option for grandparents. Because of that, in 2018, our legislator enacted a new law for grandparent visitation, which is 405021. And I have put the entire thing in the outline. I'm not going to talk about the entire thing because the case I'm going to talk about next, Pinto versus Robeson, was decided in late 2020, and it made most of 405021 unconstitutional. So for purposes, the only thing you need to know is that 405021 1A and 3 are currently constitutional. The rest of it is not. So I'm just going to talk about 1A and 3 and then talk about Pinto versus Robeson. 405020 says that a circuit court can grant reasonable visitation to either paternal or maternal grandparents. So again, it's narrowly tailored to just biological grandparents, because if you'll remember, the Washington statute was very broad. And so states have started narrowly tailoring these statutes. And the court is allowed to issue any necessary orders to enforce the decree if it determines that it is in the best interest of the child to do so. Once a grandparent has been granted visitation rights, then you can't terminate parental rights or adopt the child by a grandparent and then sever the grandparent's rights to that child. We're going to get into some more case law about that particular issue and what can sever a grandparent's rights and what can't. But that's what 1A says. Subsection 3 is weird, and I'm happy to have a discussion at the end about what everyone thinks it means, because I'm scratching my head with some of it. But I do think that the reason it's worded the way it is again, that narrow tailoring. And I think that's why Pinto versus Robeson left it in place. But some of this is me trying to read the minds of people that wrote these laws and the Court of Appeals and the Supreme Court looking at all this. So what subsection 3 says is that the circuit court may grant non-custodial parental visitation rights to the grandparent of a child if the parent of the child, who is the son or daughter of the grandparent, is deceased and the grandparent has assumed the financial obligation of child support owed by the deceased parent, unless the court determines that the visitation is not in the best interest of the child. If visitation is not granted, the grandparent shall not be responsible for child support. I read this section and I have a lot of questions. One is, what does non-custodial parental visitation mean? I think it means that grandparents could come in and say, I want non-custodial parental visitation. My son had every other week and now he died, so I want his time sharing. I kind of think it means that, and that's kind of appalling to me, depending on the facts and circumstances. It also presumes that grandparents are paying child support, which I don't know that I have seen a grandparent just take over a child's child support payment when they die. I've never seen that happen unless the grandparent already has custody of the child and is somehow sharing custody with another grandparent and they're paying that grandparent. I don't know how that would even happen, but I think what grandparents could do, and if you are representing a grandparent and their kid has just died, then one way that you could potentially work yourself into non-custodial parental visitation is to start resuming those child support payments. And then say you want to step into your child's shoes. I have big problems with that if that's how you read the statute. I don't think that's narrowly tailored under Troxel, and I do think that is trampling on a parent's custodial rights to parent their child as they see fit. So I'm curious as to why the court left this constitutional. I think they did it because they read it as being narrowly tailored, but I have a feeling that you could manipulate the system as a grandparent to start paying child support, and a mom or a dad might need that support and so voluntarily take it and not realize they fall under subsection 3 and waive some of their superior right to custody potentially, and then that case go up. So I don't really have a lot of guidance for you on what subsection 3 means, other than I have some personal problems with it and think there's some constitutional issues coming down the pike with it. But that being said, let's talk about Pinto versus Robeson, which was decided during COVID. So I think a lot of people didn't realize it existed. It was decided on September 24th, 2020. I'm going to go through the facts really quickly. They're weird and sad, like all of these cases are. A mom and a dad were divorced. The mom received sole custody of their 2 children, and she moved out of state. She got remarried to a new husband, and the dad didn't really have a lot of contact with these kids at all, which is sort of the fascinating sticking point in this case for me. But they don't go into a whole lot of details about the real big back and forth history of this case. There's 2 years of litigation before it goes up, and I don't know a lot of the history, so I would be curious to see what it is. But ultimately, mom was dying, dad moved for sole custody of the children, and over time, dad got that custody and the kids started living with dad. The maternal grandparents and the step parent filed to moved to intervene, and they both filed for custody, which is also fascinating. And after dad gets sole custody, the Robesons are the grandparents. They move for grandparent visitation under 405-021. The trial court agreed that they should be given time sharing, but also believed that 405-021 was unconstitutional. So ultimately, the trial court did not give the grandparents any visitation, which is fascinating that a trial court would make that determination. It's clear to me that the trial court was pretty pained by the decision that it made, but agreed that there were big problems with the newly enacted 405-021. So the grandparents appealed. The Court of Appeals said that 1B and C are narrowly tailored to specific circumstances, so they upheld it. And that's when the Supreme Court took discretionary review and then ultimately deemed all of the statute except for 1A and 3 as unconstitutional. I like Pinto versus Robeson. If you have a grandparent case, I think it's the place that you start because it does a lovely job of going through Troxel and Walker and getting us to where we are now. So it's really helpful if you have a grandparent case to just pull this one because it's got all of the good language in it that you need from all of the case progeny before it. So it starts out talking about Walker. And obviously, again, reiterating that parents have a constitutional right to parent their children as they see fit, and that is a constitutional presumption that a fit parent acts in a child's best interest, and that must be your starting point in all of these cases. And grandparents must rebut that presumption. It then goes into detail talking about the 8 factors in Walker, and it compares the 8 factors in Walker to the weird factors in the in 405-021. It talks about how 1B and C do not show the strength of a relationship and does not show that parents are not fit or that the grandparents have been acting as parents. So essentially what Pinto versus Robeson says is that really to win one of these, you're going to have to show that a parent is not fit. And that's an interesting thing, because the presumption is that these parents are fit. So I think that's weird language, but I really think that the court is getting at, if you have two addicted parents, which is really when these are the cases that Ann and I see when we go to the Grandparents as Parents conference, is all of the younger generation of parents in this family dynamic are addicted. And they drop off these kids with these grandparents for months at a time, and then they pick them back up. So they're not de facto custodians. They don't have a DNA case because they don't really want the cabinet involved in their lives. And these kids just kind of come and go. I think in those cases, you can really argue fitness. So if you have drug addict parents, I do think that's what Pinto is getting at. They don't specifically say that, but I think there's a fitness issue there. Otherwise, though,
fucking way.
Daniel, you're not on mute.
Oh, sorry.
That's okay. So fitness is obviously something you can touch on if there are some really legitimate fitness concerns. Hammering home the strength of the relationship between the grandparents and the child, I think is fundamentally what all of those factors are about in Walker versus Blair, or that the parents have been acting as parents. And that's what Pinto focuses on too, is where you have situations like what Ann and I see at the Grandparents as Parents conference, where for months at a time, grandparents are providing care for these children, and they never know when the parents are going to show back up. So I think that those are the kind of things that Pinto wants the courts to be focusing on within the Walker versus Blair factors, and did not appreciate that 1B and C of the current visitation statute kind of goes awry of those and is not narrowly tailored. One thing that Pinto versus Robeson really touches on is that the Walker factors are not sufficient to flip the presumption that the visits with grandparents would be presumed to be in the child's best interest. So basically the way I read Pinto is the burden of proof is always on the grandparents. It's not like grandparents have a presumption, and once they meet that presumption, the parent then has to rebut it. That is not how I read this case progeny. The burden by clear and convincing evidence is on the grandparents to prove that a fit parent is mistaken in their belief that grandparent visitation is not in their child's best interest. And that burden never flips to the parents. So there's never a burden met, now you have to rebut the presumption. It's always on the grandparents to do that. So a lot of what Pinto versus Robeson does is clarify kind of how we got here between Troxel, Vibert, and Walker, and then talk about our statute and the problems that they had with the statute. I've put in some good some good quotes from Pinto. I'll go over those really quickly. I'm not going to read all of them, but Pinto says the statute on its face runs afoul of a parent's fundamental constitutional right to the care and custody of his or her own child. The statute essentially just lets you prove a significant and viable relationship in one of four ways, and that can be met by a preponderance of the evidence, which is lower than the clear and convincing standard that was required by the court in Walker to rebut their presumption that a parent is acting in a child's best interest by limiting or denying visitation. And they've determined that the statute as it is written fails to accord with a parent's determination regarding his or her child and the special weight required by Troxel. So Troxel says that parents have a special weight given to them, and grandparents cannot rebut that without clear and convincing evidence. And then Pinto also says, even if the Walker factors, I've already talked about this actually. But ultimately they say that they are leaving KRS 405-021A and KRS subsection 3 as potential avenues for trial court to grant grandparent visitation so long as the trial court complies with Walker in applying those subsections of the statute. With this in mind, they're leaving open the possibility that the legislator may enact further grandparent visitation statutes that do comport with the Due Process Clause and accord the requisite special weight to a parent's determination of the best interest of their child. So they're kind of basically telling the legislator to fix it. But regardless, when you have one of these cases, make sure you're not relying on the middle section of that statute because it's no longer valid. In my grandparent case, the grandparents filed a petition for custody based on those 4 factors in the statute. And I filed a motion to dismiss the petition because it's unconstitutional, which of course they just amended their petition. But those are the things that can get you hung up and delay it, right? Because ultimately that delayed the grandparents getting into court because now they have a procedural issue that they have to fix. And I just don't think people realize that that case was out there because it happened during the pandemic. So another 2021 case is Blackaby versus Barnes. So again, all these cases have very complicated facts. Blackaby was the child's paternal grandfather. Barnes is the child's maternal grandmother and ultimately adoptive mother. So you have 2 grandparents fighting over a child. Dad was in jail and then he subsequently died. Mom just terminated her parental rights. It sounds like the classic case that Ann and I see a lot of just 2 parents that are drug abusers, and the grandparents are all kind of cooperatively for a while raising a child. And that is what happened here. Blackaby had time sharing with the minor child before, during, and after maternal grandmother's adoption. Blackaby was not a party to the adoption. Obviously, those are closed confidential proceedings, so I don't even know how much Blackaby knew about that proceeding, but certainly he wasn't a party to the action and had no ability to intervene. I mean, he could have intervened if he had known about it, but 9 times out of 10, people keep those things secret, and you and I as practitioners can't just look these cases up. So, but eventually maternal grandmother Barnes stopped the visits, which is why Blackaby, the grandfather, filed a grandparent action. The trial court compared Blackaby to a step parent and found that he lacked standing to file for grandparent visitation once the adoption was finalized, basically saying he no longer had any biological or any other kind of rights to this child. So the court looked at KRS 405021, the current version, and said it doesn't contemplate this situation because these facts are a little bit weird, although they're not as weird as you would think. These are normal circumstances that we see at the Grandparents as Parents conference all the time. Like when I do our little consults that we do for the grandparents, I hear this fact scenario all the time. It's just none of these people have the money to fight about it. So they're not the ones going to court over these issues. But they talk about the Hicks case, which I'm not going to go into in detail at all because, well, it's complicated and I've been really busy. So all you need to know for this discussion is Hicks found that a grandparent's rights under the grandparent visitation statute would not be cut off when a step-parent adoption was involved. So basically, if you have 2 parents and one parent dies and the other parent's remarried and that step-parent adopts a child, it doesn't cut off the deceased parents from having grandparent visitation rights. That's ultimately all you need to know about Hicks for the Blackaby discussion. But Hicks didn't talk about intra-family adoptions like in this scenario where one grandparent adopts and the other grandparent doesn't. So the court extended that to this type of situation and said that we're going to remand this case to the family court to conduct an evidentiary hearing on whether or not Blackaby can prove, as required by 405021, that continued visitation would be in the child's best interest. And for further discussions about what happened on Friday, I'm going to talk about a case that just came down on Friday. Blackaby goes into a long discussion about who gets notice of an adoption. So they talk a lot about the adoption statutes, and the grandparent visitation statutes did not contemplate this kind of fact scenario in which one grandparent's adoption of a grandchild basically divests the other grandparents of their right to visit the child and keep that existing relationship. It doesn't talk about a child's best interest at all, because an adoption severs ties to the biological family whose rights have been terminated. And they talk about the fact that neither statute requires notice to grandparents of a pending adoption petition initiated by another grandparent. So Blackaby presumably had no knowledge of this adoption and therefore couldn't intervene in the adoption, didn't know that he should have filed a grandparent action, because he didn't file an action until he lost his visitation. So the court talks about that a lot, in that it's an unrealistic requirement that a non-adopting grandparent should somehow discover the status of a confidential adoption proceeding that they don't get notice of, and they can't go get notice of. Like Blackaby couldn't go to his local circuit court and say, hey, has anybody filed to adopt my grandchild? They wouldn't have given him that information. And if you keep going like this, then you are telling grandparents they must preemptively file a grandparent visitation case to preserve their rights, so that in the future, if their visitation was cut off, they haven't lost that ability because of an adoption, which obviously the court thought was bad precedent to set, because that opens the floodgates to potentially more litigation and causes consternation between people when there isn't any otherwise, right? So the court found that, I'll just read this language to you because it's interesting. Here, Blackaby's filing of his petition for grandparent visitation was only triggered because Barnes suddenly halted the regular visitation he was enjoying with his grandchild. Only at that point can Blackaby reasonably be imputed with having knowledge that his ability and right to visit with his granddaughter might be at issue. Indeed, the record is void of any evidence that Blackaby sat on his rights or acted in a dilatory fashion in exercising his statutory right to grandparent visitation. To dismiss Blackaby's rights to spend time with his grandchild solely because he failed to secure visitation order before Barnes formally adopted the child is contrary to public policy, as well as the spirit and intent of KRS 405-021. So that's when they extended the step parent exception in Hicks to grandparents. And then they remanded it back to the trial court to determine whether visitation between Blackaby and the child would be in the child's best interest. And that was about it. So I questioned what the trial court did in that case, because presumably Blackaby had not seen this child in quite a long time by the time it made its way up to the Supreme Court. And that's kind of that damage that I'm talking about in all of these cases. When I represent a grandparent right now. One of the things I talk to her a lot about is when you pull the litigation trigger, you can't unpull it. It's done. So if you can fix these cases out of court, I think healing can come. Healing is more likely, and you can actually move forward in a cooperative manner potentially. So I think that grandparents don't have a huge constitutional right to their to their grandchildren, and you've got to practice these cases in the right way to even get somewhere with them. And you've got to be very careful about how you practice them. So on Friday, October 8th, 2021, the Court of Appeals rendered a decision. It's in the link. It's called VM versus the Cabinet. This is bad facts making bad law. But I think this law was coming under Blackaby. So, and it's fascinating because the facts are really bad. So I'm going to go through them. And it has a lot to do with the COVID-19 pandemic slowing everything down and causing bad decisions on the cabinet's part and other people's parts. And I think we're going to start seeing more of that in the coming months, I'm guessing. So VM is the grandmother. Her son impregnated a woman, and while that woman was still pregnant, he died. So grandma didn't know that woman was pregnant, that mom was pregnant. Grandma didn't know she had a grandchild for a little while. And I have no idea how, but somewhere along the way, grandma finds out she has a grandchild and that child is in foster care. So grandma contacts the cabinet and asked to be considered as a placement for the child. In the beginning of the pleadings, the court goes into great detail about the facts and kind of pummels the cabinet for how they handled this case. But they talk about in the beginning of all these pleadings, the deceased father's full name was on the pleadings, and then it said he was deceased. The mother stipulated that the father was the father. And so everyone knew that dad was dad. When grandma shows up to the cabinet and says, hey, I want to be considered, the cabinet makes her pay for a paternity test. So her and her ex-husband, the father of the deceased dad, go and get swabbed. The foster parents through the cabinet are instructed to take the child to the paternity test place and have the child swabbed. But grandma had to pay for it. And then the paternity came back as 99.6% probability that this child is the biological grandchild of the grandparents. The cabinet then did a virtual home visit. And one thing you need to know about the paternity test is it took way longer than normal because all of this started basically when the world shut down. And so even going to get a paternity test was impacted by the pandemic, and a lot of places were closed. So there was months and months that went by where this child was raised by the foster parents, and grandma has never met this child before. So the cabinet did a virtual home visit of VM's home. She found the home was suitable, and found that VM was a fit person to care for the child, but the cabinet never considered her as a placement for this child. And I'm going to own that I don't do dependency, neglect, and abuse work. And for purposes of today, I didn't get into the nitty-gritty details of all of this, other than to say that the cabinet filed an annual review and dispositional paperwork 2 months early and did not name the father on the pleadings. So they would just listed him as deceased and didn't even put his name on the pleadings. And at that point, the cabinet recommended adoption by the foster parents. At some point, grandma got an attorney, and grandma filed a motion to intervene to name her as the temporary guardian of the minor child as well. And the cabinet throughout refused to take a position on grandma. Like they didn't say, yes, she's fit, but this child's been with the foster parents since birth. She's really bonded to the foster parents. Like, we don't want to disrupt this placement. Nothing like that. They just adamantly refused to take a position on grandma and essentially just let the trial court do what it wanted. And the trial court found that grandma had no legal right to the child, that the child had never known her, and that grandma relied on law that was no longer good. I didn't go down that rabbit hole because grandma briefed it and fixed it. And then they had another hearing, and at that hearing, the trial court said that grandma could not introduce the paternity test as evidence because she couldn't prove chain of custody, which the Court of Appeals took massive issue with, as did I, because the cabinet is who told grandma, you have to pay for it. But the cabinet actually organized the paternity test. The cabinet made the foster parents take the child separately. Like, grandma's still never seen this child, to get the paternity test done and prove whether or not grandma was grandma. And then the trial court wouldn't even let the paternity test in. Bad facts making bad law. So at that point, the court found that KRS 405020, which is not the grandparent visitation statute. It's the statute that says if you have two parents and one parent dies, then the other parent has custody of the child. But that statute specifically talks about other people, parents acting as parents, and other persons can come in and claim and argue fitness about the parent. So essentially, the Court of Appeals was saying grandma could have argued that mom was unfit and that she was fit and should be able to care for her child. You also have dependency, neglect, and abuse statutes that say we have a presumption that you need to find again, I'm out of my realm, but it's my understanding that kin get first dibs at a child instead of putting that child in foster care. So the Court of Appeals said grandma has other basis for coming in the J case, even without a pre-existing finding of paternity. But I think the Court of Appeals was pretty bothered by the trial court just ignoring this paternity test. And ultimately, they found that the family court abused its discretion in denying the motion to intervene as untimely, as these factors support intervention being timely. While interventions in a dependency, neglect, and abuse case should take place as soon as possible, ideally before the dispositional hearing is conducted. And remember, disposition was filed 2 months early for some reason. Intervention can certainly be reasonable at a later juncture, depending on the individual facts of each case. Basically, the trial court said grandparents should be able to intervene in dependency, neglect, and abuse actions, but then it took it a step further and says that interventions by relatives in adoption proceedings should be freely granted so as to consider all viable options for a child. Ultimately, though, I think because of Blackaby versus Barnes and the bad facts of this case, the court also decided that when a grandparent intervenes in a DNA action, they have to be put on notice of an adoption. So they find, therefore, as a matter of fundamental fairness, all interveners whose intervention has been granted in a dependency, neglect, and abuse case for the purpose of seeking custody should be given notice and an opportunity to be heard in a subsequent adoption case so that all options for placement may be considered. Jennifer, I just saw your question. It'll be in the outline, but it's VM versus Commonwealth of Kentucky. It was decided on Friday, October 8th. Like I read it yesterday for the first time. It's 2020 CA 1593ME. I have lots of questions about this. I know it's not completely on par for grandparent visitation, but I do a lot of foster parent adoptions and I don't have access to the DNA file. I don't have a way to know who intervened in a cabinet case. I don't know how functionally this is going to work, but I thought it was important for you guys to know is it's out there for anybody doing adoptions. I also think it's important. Right, I do know you can get the DNA file with an order, and I guess one of the first things you're going to have to do in a foster parent adoption from now on is ask for access to the DNA file so you can put any interveners on notice that you are filing an adoption, which could make foster parent adoptions very interesting going forward and extend grandparent visitation in a different way. I feel for the grandparent in this case, and I feel for the foster parents. I mean, I know most of you know I adopted 2 kids out of foster care, but I feel for both people because the foster parents have had this child since birth and the parents never were involved. And then on the other hand, grandma didn't even know she had a grandbaby. And once she found out, she did everything she was supposed to do. And essentially the cabinet messed this case up. And now all these people have been harmed by it. So it's important to know that if you are going to do an adoption, that you need to make sure that anybody that intervened in the DNA action is put on notice of the adoption, which is kind of just extending Blackaby versus Barnes. And Blackaby was a 2021 case. So it's not a huge leap for this case to come down the pike, but I think it's an interesting extension of giving grandparents more rights in certain scenarios because they can technically object to an adoption now too. And I think they could have anyway. It's just now they are supposed to have notice of the adoption. So does anybody have any questions?
Okay, just one question. Does that case say they have to be granted the intervention or moved to intervene?
It says that the family court should enter an order requiring that such interveners be given notice of any adoption action so that their established interest cannot be circumvented. So they are given notice and then the grandparents can intervene. And I think the way that you read this case is intervention should be freely granted. So if you're relying on this case to intervene in an adoption, you've got some really strong language to allow your intervention.
Okay, because we had a second division case where this happened and the cabinet was ordered to provide notice of the intervention. But in that case, this is for this case, I want to go read it, I've been out of town. But in that case, the cabinet was ordered to provide all the intervention notice to any potential attorney or whatever in an adoption proceeding. which
And I
would
think that
be a
maybe
concern.
that's what I have thought about. I read this case 24 hours ago, so I'm still gnawing on it too. But I think that that may be what mechanism is going to come out of this, is that the worker. So when you do a foster parent adoption, I don't know how many of you do them, but the worker sends me the certified TPR, and that's when I know I'm allowed to file the petition for adoption. And I have a feeling what I'm going to start doing is, hey, worker, did anybody intervene in the underlying DNA action? Because if they did, I have to put them on notice of this petition.
Just be aware that Tiffany Yar has said they're not going to do that. I mean, I haven't talked to her since this case happened Friday, but in our case that went up to the Court of Appeals, that this happened and they said they're not going to do it. So just be aware of that.
Except I do think the workers will tell us if anybody intervened in the underlying action. I think if you're a practitioner, but then I also think as the person filing the adoption, I read this as me saying I have to file a motion. So I guess what I'm going to do is when I file my motion to appoint a guardian ad litem, I'm going to also ask the court to review the DNA record and determine if there were any interveners per CM versus the cabinet or BM versus the cabinet. And if there were, please let me know and I will put them on notice. That's the way
I think that's the best practice way you can proceed at this point, given that ruling. I mean, what else are we supposed to do?
Yeah, and it's frightening for foster parents, right? Because if we don't do it, and then grandparents suddenly show up 6 months after the adoption is done and say, hey, y'all didn't put me on notice. And then we have to do the whole adoption again. And it's going to make adoptions more expensive. And the cabinet only pays $1,000 for these for foster parents. So, those are considerations. I don't know that foster parents are thinking they're going to litigate at the adoption phase, because at that point, there is no other parent. So they're not anticipating a big litigation at the adoption phase. And that is concerning for me. And what that means. But again, it's a balancing act, right? Because do foster parents have more of a right than a paternal grandmother who was treated poorly by the cabinet? And this is bad facts making bad case law, because the cabinet didn't treat this grandmother correctly. And arguably this kid should have been with grandma from day one. They should have done their due diligence to try to find a grandparent and then, put that kid with a grandparent instead of a foster parent, and they didn't do their job. So it's a problem that everyone might reap the repercussions of going forward. So
I have a question.
One hopes
as someone
too,
who
and I think-
doesn't do. Go ahead, Nicole. I'm sorry.
I would say, and I think it'd be even important too for our trial judges to try to keep the same guardian in these cases. So, if I get that, this is for you all to know, if I'm the same guardian as the case below, ask me, I'll tell you. So that we can make sure that we're following that.
That doesn't matter if it goes to another county.
Right, that doesn't matter. And that's what
Right.
the case talks about. Actually, either Blackaby or VM, I don't remember which one, talks
Different
specifically
county.
about that scenario, Nicole. It talks about the fact that so Fayette County cases tend to stay in Fayette County. Like, we have enough foster parents in Fayette County that when a kid goes through DNA cases in Fayette County, they get adopted by Fayette County foster parents. But I do a lot of adoptions across the state, and those cases are rarely in the same county as the original DNA case, because they're just in these smaller counties. There are not very many foster parents. So those kids always get shipped to other counties. So you have, and I never talk to the original guardian. If I'm, if I have a Scott County adoption for a case that was in Northern Kentucky, I'm not calling a guardian up there that I don't know. In normal, now I will.
Well,
Right.
maybe this was lazy practice on my part before, but if I'm post TPR and I'm doing a foster parent adoption, I mean, it's supposed to be so streamlined and so straightforward. You barely have to do anything to do with the DNA case. You get your documents and you attach them and they're part of the record. And it would never have occurred to me before this case came out to start looking to see if there had been interveners. And
the other
I mean,
problem is
Oh, absolutely.
you can't ask your clients, like, you can't ask the foster parents what happened in the DNA case because 9 times out of 10, they don't understand.
I don't know.
Right.
They have
Yeah.
no understanding of the DNA action, and they didn't go to most of the court proceedings. Now we have all these new statutes that say foster parents have all these rights, but these people work, and if you're a foster parent, you have so many other things that you're taking off of work to do that you're required by the cabinet to do that you're not taking off for these court appearances. You're depending on the people within the legal system to tell you what happened. You're not going on your own. So I ask foster parents questions all the time they can't answer when I meet with them for their adoptions. So you're not going to get your information there. And if you have an overwhelmed worker, I don't know that you're going to get the information from that person either. So I
Right.
think
Oh, I didn't mean to imply that at all.
Oh no, I know. But I think just from a just logistics standpoint, I've been racking my brain at how complicated this is going to make foster parent adoptions. And I think it's good to talk about all these things because this is going to
Yeah, it's
complicate
gonna be
those.
stupid.
Yeah.
Yeah,
and
it's gonna be stupid, complicated.
And it sets up foster parents to suddenly be litigating with grandparents when the cabinet messed up. And that's not the
Yeah.
foster parents' fault. And it's not the grandparents' fault, right? And it's a crappy situation for those two sets of individuals altogether. And I feel deeply for all of them when that happens.
But I think your suggestion about when you ask for a GAL, also ask the court to review the record in the DNA case. I think that's a really good suggestion.
Yeah, because then if the court issues an order that says there were no interveners in the underlying DNA action, you're off the
You're
hook.
covered.
And I think from just a malpractice standpoint, that's what you need for your own practice. So
We have time maybe for one more quick question, if anybody would like to unmute themselves and chime in. Our folks are starting to leave. All right, so I'm going to thank you, Ann and Anna, again for the excellent presentation. Our cases that were covered in today's presentation are posted in the FCBA website, and also there's a link to that location on our chat here, so you can click on that before you leave this meeting. Thank you very much, and if nothing else, I hope everyone has an excellent day.
bye, everybody.
Thank you.